Good evening, this is Rahul Reddy, live here from Houston, Texas. Reddy Neumann PC brings in immigration updates every week on Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. Along with me is my business partner, Reddy Neumann. Emily, there are a lot of rumors going on that this Trump administration is going to all of a sudden change its heart and will allow everybody who has an I-140 to apply for adjustment of status. Can they actually do it? Or will they do it? Or what do you think about it?
I mean, can they do it? Sure.
Okay.
Will they do it, I think, is the better question, and I just don't see that.
There are rumors floating around that this is the information leaked from the Trump administration. Do you see any truth to it?
No, I don't. I don't think it's actual information that was leaked. I think it was a statement in response to someone's question about what could be done. In the grand scheme of the world, there's plenty of different possibilities that could be done, but it was not meant to say that in reality this is what will be done or that they're planning to do that. I just don't see it happening.
When the leaks occurred before, though, they were clear. I mean, we would be able to judge that the leaks came from the administration. We have also have, our guy announcing it on the Twitter and also shouting it out in the meetings, even though he did not think about all the process that are involved in, and President Trump has leaked the information out. But this particular thing definitely did not come out from the administration that the USCIS or the Trump administration is going to allow all the people to file the adjustment of status when the I-140 is approved if the priority date is not current. It was just a question, ideally, can USCIS do it? The answer to that question is yes, they can. Under certain conditions, they have an authority to allow two people to file the adjustment of status. But will they do it? I mean, the difference is, I don't want to tell my age. Am I eligible for the 2024 Olympics to join the soccer team from USA? I mean, the technical answer is yes, I can. Oh, but you're very old for the soccer team. Well, that's not one of the criteria to get to the selected team. If I'm the best player, I should be there. So the question is, can I be selected to the soccer team going to the 2024 Olympics to Paris from USA? I'm a US citizen. So the answer is yes. What are the probabilities for it? Well, I'm not going to answer that. I myself, I'm a good soccer player, but you know how it is. So at this point of time, with all what Trump administration is doing, what they are telling, what they are implementing, the way that they reacted to the immigration since the time they came into power, we do not anticipate that this administration is looking forward for allowing to people to file the adjustment of status when the priority date is not current, even though they have an authority, but I don't think so they will do.
Yeah, I don't think so either. I mean, people think that, especially based on some of his latest statements about merit-based immigration, and he's planning some big executive order on that. His idea of merit-based immigration, I think, is quite different than what we would think of as merit-based immigration. His idea of merit-based immigration is eliminate the diversity visa, eliminate some categories of family immigration, eliminate asylum, eliminate refugee status, eliminate DACA, eliminate TPS. What else can you get rid of that's not based on so-called merit? That's what he means by making
Doesn't it mean that he will add some extra green cards? Doesn't it mean that he will take the per country limit off? Doesn't it mean that if I have a master's degree and I have a job of $250,000, I can get a green card? Is that what it means?
No, I don't think he can do any of that by executive order in order to change the way green cards are distributed. I mean, that's clearly set by Congress. Congress has to act on that. Could he change the wage requirements maybe for H1Bs or how the lottery is done? Not by executive order. It would have to be through the regulatory process. So yeah, there's some chance there, but it's not something that overnight he's a dictator and can say, I'm going to do this to let all the employment-based people get a green card. I think it's kind of delusional to expect that to happen.
You did raise one other theory here, Emily, is that since the family-based immigration is almost banned from March of 2020, I mean, most of the people do come from outside the country, it's almost banned from March of 2020, and it's banned all the way to December of 2020. Then we do have a lot of restrictions for the business immigration too, for the green cards, because from March onwards, USCIS office has not been opened. Recently, they started a little bit. They started interviewing people a little bit, but not to an extent what they normally would have done. So don't you have the spillover coming in and then say, okay, we have so many green cards, can everybody be current? That's what happened in 2007. Mm-hmm. Could it be happening again, or what are the probabilities for it?
So yes, we expect that there will be spillover from the family-based cases that are going unused this year to employment-based next year, beginning October 1st. That is predicted to be around 80,000 green cards. Now, those are going to be divided up by the categories. So EB1 gets their set amount, the 28.6% amount of that larger number. EB2 gets their percentage of that larger number. Same for EB3. So we still have the per country limit though. Now, yes, if the rest of the world doesn't use up their increased allotment, then whatever's left over does spill kind of sideways to those countries that are most backlogged. So we should see some forward movement for EB2 and EB3 and EB1 India. Will it be current? I don't know, because with the final action dates, they can only accept cases that they think that they can adjudicate and where the green card will be available within 1 year. That they're limited by statute on that issue. We have processing times that are going on 2 years at some of the local offices. So how can we possibly move the dates forward enough to use up all those green cards and get everybody actually, do we really think USCIS can adjudicate 220,000 employment-based green cards in 1 year? They couldn't even do 140,000 this year. There's green cards that are wasted right now because they can't process them all. So I don't know. I don't have high hopes.
Emily, I have some problems with what you just spoke. You said that the unused family preference categories will fall into the employment-based category for the 2021, which actually starts on October 1st of 2020. And we both agree that the employment-based green cards, we have 140,000 green cards available, and they block the consular processing of the green cards. And now the green cards that were supposed to be given, they are supposed to be interviewed between March of 2020 to almost to September. It seems that the interview processes were nil, or in some cases very little. Won't the spillover of the employment and the unused 140,000 be given next year, so that not only you said the 80,000 that is for the family preference categories will be used by the employment-based, but also the employment-based spillover cannot be used?
No. Employment-based, if you don't use it, you lose it. So any green cards that are left unused on September 30th disappear. They do not spill over to next year. So only the family-based from 1 year spills over to employment-based the following year. However, right now Congress is working on their DHS appropriations bill for next year, and several amendments have been added to that just within the last half hour here, from what I'm gathering. And one of those amendments to the appropriations bill says that those unused employment-based green cards from this year should be remaining available to be used next year. It also says the diversity visas that went unused this year should be available for next year, and the family base that went unused should be available for next year. So that is something that's being done by statute. It's in Congress right now. Who knows what the final bill would look like? It has to go through the Senate. They're going to have their own amendments, and then they try to conference and come up with an agreement. They might agree on nothing, and the bill goes nowhere. So there's a chance, if Congress has its way on this issue, maybe those family-based visas won't become available for employment-based. But definitely, right now, employment-based visas that go on green cards that go unused in this fiscal year do not spill over to next year.
That's not good. Emily, we do have an executive order that banned H1Bs, H4s, L1s, and L2s, J1s and J2s coming into United States to get any new stamping. Then we have a tweet from the Department of State saying that, ooh, that's not the way it is, and there's a different way. I mean, how come these things are coming in tweet when they're supposed to be coming in the website of the USCIS in a policy memorandum or so? And can you explain what are the things that are changed in the past 1 week about this this executive order banning the H1s and H4s and L1s, L2s, and J1s and J2s?
Right. So when the order first came out, the question was, it says it applies only if you're outside the U.S. So we were questioning, okay, if I'm currently in the U.S., maybe I should be exempt. But the Department of State kept coming back answering questions on Twitter saying, no, if you need a visa, even if you were in the U.S. on June 24th, if you're now outside the U.S., you still can't get the visa. And they didn't say anything about dependents. Of course, there's been a number of lawsuits. The most recent one was literally just filed about 30 minutes ago by the U.S. Chamber of Commerce, just showing how ridiculous this idea is, especially when you're talking about H4 and L2 dependents who, you know, are not taking jobs, especially when we're talking about kids. And this is all being done for the economic aspect of it. And so slowly over time, through tweets, the Department of State is walking back their original interpretation. So now, if you are currently in the US in H1B status or in L1 status, and your visa is expired, and then you travel, you can get the visa. If you're currently in the U.S. in H or L status, maintaining proper status, and your spouse or children are outside the U.S., they also can get the visa, the H4 or the L2, even though they were outside the U.S. on the day the proclamation took effect. So they really scaled back what they had originally intended. I think the fact that they're doing this by tweets, and then finally later they updated their website, and then the website update was even more vague. I think that's on purpose. I think their goal is to create chaos, to make people question whether they qualify or not, and then maybe choose not to apply because they're not sure. It's all meant to limit the number of people that can receive a visa and come in. So I think that was done by design.
Emily, you said Chamber of Commerce has filed a lawsuit on the Trump administration for the executive order. What if individuals who are affected, for example, if there is a person who got stuck in India right now, and he has a H1B approval and he's unable to get the visa, can they file a lawsuit individually? If they can, is your office doing anything to get them filed the lawsuits?
Yes. So as of this moment, we already have one lawsuit that has been filed on behalf of a number, specifically for Indian nationals, on behalf of a number of people who are stuck outside the U.S. Either they're stuck or their dependents have been stuck, not able to get the visa because of this executive order. So that lawsuit is also already filed, but what we're doing right now is we're able to accept new people into that existing lawsuit to be able to amend the complaint to add more people in. The benefit of this is, number one, we don't have to file a second lawsuit, which can be more expensive, but number two, it cuts down on the amount of time that you have to wait to get a result out of the lawsuit. So our office is currently looking for plaintiffs to add to this existing lawsuit. If you're interested, if you are an H1B or holder outside the U.S. and you are stuck, or your H4 dependents are in the U.S. and you're stuck outside the U.S. and can't get your H1B stamp, you can email us at litigation@rnlawgroup.com. We'll send you the information that you need to understand what the process is and how it works, and then you can decide if you want to join. This is going to be a very fast process. We're looking at needing to file this by Friday or Monday, like literally a couple of days from now. So If you are interested, please email litigation@rnlawgroup.com, and we'll do what we can to get you added to that pending case to try to speed up the process for you.
Emily, we have seen an article on Forbes just now, today, saying that the legal immigration has been cut in half. Is there any truth to it?
Absolutely. They're looking at all those things I mentioned earlier about how the Trump administration is trying to create its version of merit-based immigration. That's what this Forbes article is talking about. So they've already cut refugees down to practically zero. They are cutting asylum down. The diversity visa lottery is down. Family-based immigration is down. The only thing that's actually increased or expected to increase for next year, at least based on the projections, is employment-based immigration. But overall, when you take all of that into consideration, it's projected that from the time Trump took office until next year, legal immigration will be cut in half.
A lot of requests are coming on face masks. One thing is that we had some issues in our office. So we are maintaining a lot more stricter standards than normally required. So please be respectful for our health. It is very important for us, you to be healthy, and also, ourselves to be healthy. Emily, on the USCIS furlough of the employees, how is it going to affect the timing? Do you think there is a chance that USCIS is going to be shut down, especially 1/3, or do you think so Congress is going to act? Congress has given almost $1 trillion to all the different things. Can they not give $1 billion or $2 billion to the USCIS?
So, obviously we can't predict the future. My personal thought is that they're going to be negotiating on this and they're going to work it out at the last minute. So I'm expecting that there won't actually be any furlough, but it's going to go down to the wire. Just that's how politics is. But if I'm wrong, hopefully I'm not, but if I'm wrong on that, what happens when USCIS, has so few employees that they can't function? The main thing is I would expect that processing times, of course, are only going to get worse. I would assume that they're not going to be able to schedule interviews. It's going to take longer to get EADs. It's going to take longer to get green cards, longer for citizenship. I would expect they probably would eliminate premium processing because there's no way they can comply with a 15-day processing time. So all around, it would be a huge impact on the legal immigrant community and their employers because we need to have continued employment authorization. We need receipt notices to be issued to document and complete the I-9 process correctly. So it'd definitely be a huge problem nationwide, but hopefully we won't make it to that point.
Emily, on the H4 biometrics, have you seen anybody getting scheduled with the H4 biometrics?
Yes. I had a list in my head. I tweeted it out yesterday. Off the top of my head, we got notices for Jacksonville, Hackensack, New Orleans, Houston, one of the appointment locations, I want to say it was North, and also one in Dallas. So we are seeing them come in now. They are also giving a little more time for you to prepare for it. Last week I had mentioned that we literally received appointment notices on the day of the appointment. Now they are giving more advance notice on that, so they are coming in. So that's definitely a good sign.
Harish Gupta has this question. I'm going to go to question and answer. He said his H1B is stamped in March 2020, came to USA in June 2020, assuming that he was here on June 24th of 2020. His wife and his kids can go for H4 stamping based on the new modification by the Department of State. We don't see that as a problem at this point of time. They should be able to get the H4 visas.
Samir from Facebook has filed an MTR appeal due to an H1B denial that was filed in April and wants to know kind of what the processing time is like on that. So MTR and appeal are two different things. MTR goes to the USCIS office that made the decision. Those processing times could be anywhere from a few weeks to 5 to 6 months. There really is no set processing time for them, so they can take as long long as they want. An appeal is usually even longer. They tend to stick with an average processing time of 6 months from the time the case actually reaches the appeals office, which is usually about 2 months after filing. So you're looking at more like 8 months for an appeal to be processed.
There are too many questions on the merit-based green cards, though. At this point of time, we are not giving very serious thought of the merit-based green card, that it should be evaluated at this stage where we are in right now. And we did point it out before that the Trump administration by themselves, without going to the parliament, which we call it as Congress here, cannot just change the entire immigration just by a letter or by the regulation. They have to go to the Parliament, and the Congress right now, which the Parliament is definitely divided. I mean, the lower house is in the hands of the Democrats, the upper house is in the hands of Republicans, and in the upper house, which is called Senate here, they require, for most of the bills, they require 60 votes out of 100, and no party has the majority there. So it's all split around, and nothing gets passed unless it's very urgent or is absolutely needed. And right now, to expect a merit-based immigration to be passed before December, that's when this administration is going to be in there, and unless they get re-elected. So the chances for that at this point of time, I would give it as less than 1%.
Right? I would agree, yeah.
Yeah. So at this point of time, to think about what will happen, what's going to happen with all those different things of the merit-based, I think so it's too premature. And even if it is, we don't have any content. Even if that 1% that you think is going to happen, it's not. There is no content there for us to evaluate and tell you which way. So at this point of time, we recommend that you plan your life according to the existing law, the regulations that we have right now, rather than plan your life based on that 1%, and we don't even have the content about it. So I don't want to take the questions very seriously with regards to the merit-based green cards and what are the content in those things.
Harish from Facebook wants to know about whether the executive order applies to his situation. So he is currently in the U.S. He has a valid H1B Visa stamp that he got earlier this year in March and has been in the U.S. since June of 2020. He wants to know if his wife and children can go for H4 stamping now, and the answer is yes. We finally have confirmation on that. As soon as the consulate reopens, they are eligible to get the H4 stamp in that situation. Yash from Facebook also has an H4 question. He filed his wife's H4 extension online using the online I-539 application. He's already got his H1B extension approved till 2023. He only has a receipt number for her. He wants to know if she can continue to remain in the U.S. Because she hasn't gotten the biometrics appointment notice yet. So as long as the I-539 was timely filed, meaning before her I-94 expired, that pending application keeps her in a period of authorized stay even after her current I-94 expires. So yes, she can remain in the country as long as the application is pending. One
question I need your attention only, that this person wants to know about the 2021, that means the H1Bs that have been filed between April 1st and June 30th. Do you have any stats for it?
Yes, so I posted yesterday on immigrationgirl.com kind of our first round of statistics. Those of you that have been with us for some time are aware that usually every year in March and April I share statistics on what's going on with our firm's cases to give you an idea of where we're at with receipt notices and rejection notices and the lottery and the processing times and all of that. Obviously this year is quite different in how we actually processed the cases. So it took me a little bit of time to decide what statistics might be most helpful to you. But I do want to share that if you have not received your receipt notice yet, you are not alone. A lot of people, and off the top of my head, I can't remember what the percentage is, but it was quite high for our office, have not received their receipt notices. It seems like especially the Vermont Service Center is taking quite long on that. So if you haven't received it yet, but your case was filed by June 30th, you're not alone. We've received approvals in only about 10% of our filings so far. So they're very early on in this process. It's going to take time. It may go beyond October 1st like it has in previous years, so you may need to consider premium processing if your OPT cap gap is expiring on September 30th to make sure that you don't have any gap in employment authorization.
Kishore from YouTube has the question of the day, I would call it. How is the USCIS processing 485 applications in light of the I-944? Yeah, credit score, public charge rule, please answer. Have no clue, Kishore. I think so. That form is a nightmare for everybody. One thing I can tell you, Kishore, is that as Emily was pointing out, the backlog for the adjustment of status filing is approximately 2 years, and we had this I-944 form only from March of 2020. Correct me if I'm wrong, Emily. March of 2020. So we don't have any of these applications processed yet. Those applications which have been filed. I can't tell. I can for sure tell that what this administration wants to do is to delay the entire process so that nobody gets a green card, or at least if they do it, it'll be very minimal. That is what exactly the administration is planning. So this is a process. This administration has changed its policies in the past, since the time they came in, hundreds of times. And because of the change of the policies, the delays are causing not only delays, the USCIS has gone bankrupt. From August 3rd, that's approximately about 15 days from now, the USCIS is going to be bankrupt because of all these changes, including your comment of the I-944. They are intentionally doing. Unless we get some relief from the courts, though, we may be doomed with this administration. Everything will be delayed.
Bimmy from YouTube wants to know about advertising for the perm process during the COVID-19 situation where everyone is working remotely, and if the prevailing wage needs to be done again. So I think that with the prevailing wage process and with the recruitment process, the employer always has to recruit wherever the location of employment is, and if they have moved that location of employment remotely and that's going to be a permanent change, it may be necessary to go through the prevailing wage process again because now the job is different. Now it's located remotely versus in the company location. However, I think the majority of situations it's not a permanent change, it's a temporary work location, and they all plan on moving back to the office location when this situation is over with. So the prevailing wage itself remains valid. The only issue then becomes, can they appropriately do the notice of filing, which has to be posted as a hard copy at the physical location, and can they do that if no one's there to see it, and what do they do? There's no guidance from the Department of Labor on this, and they're not planning on issuing any. All they've said is you must comply with the physical posting requirement. So the question is, do you comply with the physical posting requirement, and if no one sees it, is that okay? Or do you need to take extra steps to make sure that in addition to posting that, the impacted employees actually get the notice, and is that going to be enough? Or is it going to be necessary to actually delay the perm filing until a time that the posting can be done properly? There is no answer to that question, so it's all going to be up to what your employer and their attorney decide on how much risk they're willing to take, whether they prefer to wait to ensure approval or if they want to give it a try with some alternate ideas.
Pashumurthy asked this question from Facebook. He got married to a US citizen. He filed the green card application in March, and he still has not received the fingerprint notice as of now. Is it going to take that much time? The answer is that under the normal conditions, though, you should have got the fingerprint notification, biometrics notifications by this time. But because the biometrics were being closed for most part from March to all the way to July, and only starting from July 15th of 2020 July 15th of this month, they started issuing the biometric notifications. You have been delayed because there are a lot of people who are ahead of you. So that's the reason why the delay is happening. So you are in a good position. As long as you have received the 485 receipt notice, I don't see any problem for you. Gurunath from Facebook has this question, that you guys said that the family immigration unused green cards for the year of 2020 will spill over to 2020. What do you expect? Do you expect some movement in EB2? I and Emily was discussing, Emily was calculating that it's going to be 80,000 or so family immigration that is going to fall into the categories of EB1 and EB2, and EB2 out of 80,000 will get 28% of the green cards of that 80,000. However, though, the 7% per country limit is still there. So if the other countries don't use, like the way most of the time EB2 is current for the other countries, that extra percentage, that 28% of all the 80,000, that means extra 20,000 may all be given to the Indian nationals, though. There is a chance for that. It looks like there is a good chance for it. Since your priority date is August 2009, will it be current? Most probably for you, the answer will be current. Having said that, Mr. Gurunath, I have to raise my hand and admit that I have gone wrong in predicting the priority dates 1,000 times. And this is also a lie. It's much more than that. But I hope in your case that it becomes current soon.
Rashmi from Facebook has a common question with these B2 extensions that we had to file because of not being able to exit the country. So she applied for a B2 extension for her mother before the I-94 expired back in March, but only requested a 3-month extension and wants to know, because the application is still pending, can she actually stay for 6 months? No, to do that you would need to file another extension. So you need to think of what was the end date you requested in the first application and file another application before that date, and you can request 6 months from that date for a total of 9 months. We normally do not recommend filing multiple I-539 B2 extensions, but in this situation there's no way to avoid it because you can't get out of the country if there's no flights.
Question from Mr. Mazumdar from YouTube. Very good question. Do you think so that EB1 will be current in October? Any luck? I think so. There is a good chance of the EB1 to be current for Indian nationals. In fact, yesterday we got the priority date moved almost like about 10 months for the month of August of 2020. As Emily has pointed out, that out of the 80,000 excess unused green card of family immigration, 28% will fall into EB1, since the other countries are not using that much though. Those 28,000 can be used for the overused countries, which in this case happens to be mostly Indians, to a certain extent Chinese national also. What do you rate, Emily, that if Mr. Mazumdar is asking us that is it going to be current in October for EB1? What do you think? How much percentage do you think so for EB1?
I think the filing dates may be current. Okay. I don't know about the final action days, but if the filing dates are current, hopefully that means we'll be able to use them, so at least you can file
for the month of August, though, the USCIS has said that don't use the filing dates, go for the cutoff dates, though. So at this point of time, could I safely tell to Mr. Mazumdar that it's 50% chance? Again, Mr. Mazumdar, I've gone 1,000 times wrong. Go back and see the video, but I hope, I'm hoping very positive for you for the priority date to be current.
Ravi from YouTube wants to know if an H4 person can go to the Mexico border and turn around and come back to get the updated I-94 because of an issue with the I-94 expiration date. The short answer is yes and no. So you have the valid H4 visa, which allows you to re-enter. That's not the problem, so you're not subject to the travel ban. However, if you are entering and coming back from Mexico by land, You can only do so if you're an essential worker, which probably if you're an H4, you may not qualify. So you won't be able to get back in if you are coming by land. You may be able to do this by air. We had somebody just this past weekend who was able to take a quick trip to Cancun over the weekend and came back, no issues at all by air to get their I-94 corrected. Definitely, whatever you do, please talk to an attorney, a qualified immigration attorney, before you make any travel plans in the current environment. But that's what you need to look out for, is the current Canada, US, Mexico land border restrictions on only allowing essential people in and out.
Govinda from Facebook has this question. His in-laws have a B1, B2 visa. Can they come in September? Will there be an issue with immigration? At this point of time, there are no restrictions. There are some slight restrictions if they have traveled within 2 weeks to China and to Brazil. Some light restrictions are there. Just check out those COVID restrictions. But as such, at this point of time, there's no restriction. People from India can travel to United States without much problem if they have a B1, B2. The restriction is more actually from the India. They are not allowing flights to come in, but as such, from the USA, there's no restriction for the B1, B2 people to come into the United States. Raish Ansari has this question. Can a H4 EAD person work for an Indian company remotely and get paid in Indian rupees? One thing is, Ramesh, you can work remotely for an Indian company. But getting paid in India is a violation according to the IRS rules. If you are located in United States, you are working in United States, it doesn't matter where you are getting paid. You are subject to the taxes of the United States. I normally say that where your butt sits is where the rule applies. Do you have the work permit where your butt is sitting? Yes, you do. You're getting paid, so you are supposed to pay the taxes where you're sitting at, not somewhere else in India. So as far as the immigration is concerned, you're fine. As far as the IRS is concerned, you have to pay the taxes in USA.
Neerajan from Facebook had an EB2 I-485 adjustment of status interview that was scheduled for March but got canceled, and wants to know if USCIS has resumed with rescheduling those interviews and if any of the executive orders have an impact. I haven't yet seen any rescheduled adjustment interviews. I don't know if you have, but I have not seen any. I have had a couple of cases that actually got approved without the interview, so hopefully that might be possible for you, but I haven't seen any of those yet.
These cases are actually filed after March of 2017. They got approved, is that right, Emily?
Yeah, and as far as adjustment of status cases, executive orders do not have any impact on those processes right now.
One second. Is the premium processing allowed from change of status from H4 to H1? Yes, it is allowed. You can. If you have already been counted toward the H1B cap, you can move from H4 to H1. If your H1B is pending under the cap right now, you can convert into premium processing. A lot of people are asking question, is there a chance that the premium processing can be taken off or delayed once this furlough happens? We don't know yet. Ideally, it should not have been, because the reason why they are furloughing is because they don't have the money to pay the salaries. And you want to pay the $1,400, they don't want to take it. Doesn't make any sense to me at all. But obviously, there are too many things this administration has done that doesn't make any sense to me. It doesn't make any sense at all. So we have to see on August 3rd, the USCIS will notify if the furlough happens, what are the things that they are going to consider priority, what are the things that they are not going to consider priority. The last time I saw a furlough was probably before 2000, Emily.
Yeah, I don't remember there.
Yeah, well, you're not a lawyer at the time.
I know, so that.
Yeah.
Raul from Facebook ended up getting an H1 transfer approved beyond the actual 6-year limit and wants to know if he gets his I-140 approved in time before the actual 6-year limit is reached, can he just use that approval to continue to stay? I would say never rely on a USCIS error. It can very easily come back to bite you. So assume that your actual max out date is the end date of that approval and get your I-140 approved in time, and then file an extension by that date. Don't rely on the extended time that you got by mistake.
Gil Garcia has this question. He is on L1A visa from past 8 months. Can he apply for the green card and get the green card without leaving the USA? Yes, you can. You can file, your company needs to file an I-140 application under the EB1 process. If you're not an Indian national, most probably the priority date is current, so you can file the adjustment of status. If you're an Indian national, there is a chance that the priority date might be current soon. So either way, your company needs to take the initiate and file the I-140 application for you to get the ticket to get the green card. Yes, you don't have to leave the country and get the green card by staying in the United States.
Prostunize from YouTube has an I-94 expiring in September along with his wife's EAD and wants to know if it's recommended to file the extensions in premium processing in order to save her job. Unfortunately, even with the premium processing, her EAD application won't be approved any faster. They are separating the H4 and the EAD application, and also the L2 and the EAD application. So even if the H1 or the L1 is approved in premium, the remaining applications are done in regular processing according to the I-539 processing time. So there's no necessity to do premium processing as a way to speed up the EAD processing.
A lot of questions are asking the question that, oh, my priority date is this, my priority date is this. I took some guesses before, but I have told in between that I have gone 1,000 times wrong in guessing the priority date, and that is also a lie. So please excuse me for that, answering that question. We tried to put a video why this priority date moves forward, moves backward. I mean, we tried to explain it. I bought like about 5,000 marbles, different color marbles, to come up with an explanation. We couldn't do it in a proper explanation though. Hopefully one day we will, get some intelligent way of doing it, maybe by a cartoon. If anybody can help to do the cartoon, maybe I can try to do that. But as such, we couldn't explain how the priority dates move backward and forward, and why you cannot take an educated guess on when it's going to happen.
Sheikh from YouTube has a situation where his H1B was selected in last year's lottery, but just now got approved as a change of status, but then he lost his job, and he wants to know if he can transfer that H1 to a new employer when he hasn't received any pay stubs yet, or even a social security number. So from the day the change of status took effect, I've been successful in arguing that you can use the 60-day grace period after the termination of an employment and file a transfer within 60 days without having those pay stubs. Can I guarantee it will work every time? No, but I haven't had any issues doing that in previous years.
Maybe I need your attention to this question coming from Anup from Facebook. His H1B has been reopened and reconsidered. How long it's going to take? My question is, can we convert it into premium processing right now?
So this is after a denial?
Could be after going to the court, or maybe after the motion to reconsider. So it's been reopened and reconsidered.
Okay, it's not a fast process. I had this happen once last year, and it took over 6 months for them to get the case actually reopened and issue an RFE on it. So even though it got reopened, it did not result in an approval. It resulted
Can I try
in
the premium
RFE.
processing?
I tried that. It's very difficult to get them to accept it because the case is not really considered to be pending with the service center even after it gets transferred back. I've never been successful in getting a case at that stage upgraded to premium, and I have tried multiple times.
Amresh has this question. He filed premium processing. It's been 2 months. Is it common nowadays? I wouldn't say that it's common, but I would say, Amresh, that approximately around 10% of the cases are beyond the processing times for the premium processing. All they will do is that, hey, it's been more than 14 days or 50 days that my H1B is not approved, the USCIS will refund the money. That's not what you want, but that will be the only thing that you will get at this point of time since it crossed time. Did this used to happen more frequently before? No. Previously, it was a very rare scenario. Out of every year, we used to get to hear 1 or 2 cases. But Amresh, recently we get to hear these things very many times. Almost daily basis, I get to hear this, that the premium processing, they did not honor it.
Santosh from YouTube has an approved H1B, but of course the H4 is still pending along with the EAD extension, and wants to know if there's any way to get that expedited. So we've mentioned many times on here that in the past we were successfully able to get those expedited through litigation. The COVID-19 situation, because they stopped the biometrics notices, that threw a wrench into all of that, and we've not been able to file another lawsuit since that started. We see very rarely anyone getting any success by other means to get it expedited. You call and request an expedite, it gets denied automatically within 24 hours. You contact your congressman or senator, they put in an inquiry, and then it comes back and says it's within the normal processing time, there's nothing we can do. Submit an ombudsman request, they say it takes 5, 6, 10 weeks just to get a response out of the ombudsman, and it's simply cases within the normal processing time. So other than litigation, we've not found any other options. We just can't do the litigation right now because it's also not working.
Anil has this interesting thing that he saw a tweet that if the USCIS will allow people to file the adjustment of status, actually that will generate a lot of money for the immigration. That may not be true, Amit. Here is the reason though. In the H1B, when you transfer from one company to another company, some of these companies are paying approximately $6,000 filing fees plus the premium processing thing. And the filing fees for transfer of H1B application is very much. The extension application may not be that much, but at the same time, most of the people do file H1B extension with the premium processing. That's one of the good revenue. If you file the adjustment of status, I'm just telling you the maths though here. If you file the adjustment of status fees is only $1,225. And there is no EAD filing fees. There is no advance parole filing fees. Not only that, if the adjustment of status is pending for 10 years, every year they have to give you the EAD and advance parole without charging any money under the current law. So practically, if I were the guy who were to decide the things on the money, keep you on H1B and give you the green card for $1,225, I'm going to keep you on the H4 EAD. I'm going to keep you on the H1B. Now, this is not what I want. I'm just telling you the mathematics. Obviously, the government, I am thinking, is not going to make a decision of which one is profitable. That should not be their business. But since you asked me the question, which one is more profitable for them, I'm answering you this question.
Sandeep from Facebook was recently promoted to a manager at the beginning of the year, already has an approved I-140 in EB2, and is in L1 status expiring next year. He wants to know if it's possible to move to EB1. So the requirements for EB1 are slightly different from the L1A. So it depends on, yes, you may be in a managerial role now, but also depends on, was your position outside the U.S. a managerial role, or did you come on the basis of a specialized knowledge role in the foreign country? So you had to have been a manager or executive outside the U.S. and now a manager or executive inside the U.S. just to qualify for EB1C. On top of that, Not every manager qualifies for EB1. There are lots of people that are considered managers that have nobody actually reporting to them. They're more functional managers. Those cases are more difficult to get approved. Not necessarily impossible, but it's a different standard. And even if you are a manager of people, you have to prove that those people that you're managing are professional level. So they all also have bachelor's degrees. So there's a lot of documentation that has to be submitted, not just your organizational chart to show that you have people under you, but also what is their job duties, what are their education backgrounds, provide their pay stubs or W-2s. It's a lot of corroborating evidence that's needed to get an EB1 case approved.
Atik Khan has this interesting idea. Hey, what about 20K for green card? It's not practical, I think, because it's not going to be, the government of this country is not going to just sell the green cards like that. That's not going to be. Question from Mastan Sheikh. His I-140 has been withdrawn. His new employer has not started the green card process yet. Will it be a problem for the next extension with the same with the new company if they don't file an I-140 and get the I-140 approval? Mastan, it will depend upon when was your I-140 approved, when was it withdrawn. If the I-140 has been withdrawn, I-140 has been approved for more than 180 days, and then it's been withdrawn after 180 days, and that too after January 17th of 2017, then since it's been more than 180 days after the approval, they have withdrawn it, that I-140 priority date will belong to you. You can use that I-140 for getting the H1B extension with your new company, next extension. You can also move with company A's I-140 to company C, even though company B never filed the I-140. You can also use this I-140 to get your spouse H4 EAD. The only thing that you cannot do with the withdrawn I-140 is if by any chance the priority date becomes current with your existing company. If they don't file the labor and I-140, they cannot use the previous company's I-140 to file an adjustment of status. That's the only exception. This question came out if they can use the previous companies to get the adjustment of status filed with the current company. No, you cannot. The current company needs to file a labor and I-140 when the priority date becomes current for you to file the green card application or adjustment of status application.
Vikesh from YouTube wants to know what the difference is between the final action date chart and the filing date chart in the visa bulletin. So the final action date chart is the traditional chart that we've always gone by for when you actually can get your green card approved. Your date has to be current under the final action date chart in order to actually get your green card approved. And that has always been the chart that everybody used for years and years and years until 2015. The reason that they created this other chart is because if USCIS moved, or if the Department of State moved the final action date chart forward too slowly to where they didn't take in enough cases, and then green cards could go unused. Like say that they pushed the chart forward in July towards the end of the fiscal year, and they take all these cases in, there's no way USCIS can approve all those applications between July and September. Green cards went unused. Going the opposite direction, if they moved the chart too far forward early on and then they got too many applications to where they used up all the green cards before the end of the fiscal year was over, that's when we get retrogression, and the chart became unavailable towards the end of the fiscal year. So they call that like a whiplash, where you're constantly bringing the dates forward and backward and forward and backward, and they could never predict how to move it smoothly for better processing. So they created the second chart, the filing date chart. This is a prediction of where Department of State thinks the final action date chart will be at the end of the fiscal year, 12 months later. So the filing date chart should always be more advanced, and they allow you to use that chart to file your adjustment of status, typically early in the fiscal year, like the month of October, so that USCIS can get more cases in and has enough time to process them all by the end of the fiscal year so no green card goes wasted. Hope that makes sense. It's very complicated.
We should have, separate segments for these things, for priority dates, the cutoff dates, and also on the filing dates. These are very important questions. Good questions, though. Bunny has a question, and another person has the same question too. Is it okay to convert from B2 to H4 without going outside the country? And how long does it take for the change of status? Bunny, if the person is in United States right now, and they came on a B2 and now they're married, they can file the H4 before the B2 expires, the B2 I-94 expires. The H4 might take approximately 8 months to 12 months for the H4 to get approved. But once you file a H4 application before the I-94 expires, that person can stay in United States until the H4 is adjudicated.
Preetham from Facebook wants to know if you have a green card EAD, meaning you filed your 485 and it's pending, but the I-140 was revoked by the previous employer because you changed jobs, do you still need to apply for a new perm and new I-140? Good question. So in this situation, if your 485 has been pending for at least 180 days and you find a new job that is in the same or similar occupational category, you qualify for AC-21, which means you do not need a new perm or I-140. All the new employer has to do is submit a supplement J, I-485 supplement J, to confirm that their job offer is similar to the previous job offer that you had. So if you have a pending 485 for 180 days or more, and the new job is in the same or similar occupation, you qualify for AC-21 and can move the process to the new employer without starting over.
Question, one person got stuck in the 221G. I'm assuming it's for the H1B. Can they get a visa once the consulate's open? Unfortunately, no, you can't. You have to wait until January 1st. Unless the court gives a judgment in favor of us, in favor of you and me, of course, then it's a different issue. But at this point of time, under the current executive order, no, they won't grant you the H1B visa, even though you have applied before. Okay, it's time now.
I guess it is. Thank you so much for joining us today. If we did not get to your question, you can always join our daily conference call. You can go to rnlawgroup.com to get the dial-in information for that, and check out immigrationgirl.com. I do have the updated statistics on H1B CAP processing there and what's going on with the travel ban. You can always follow me on Twitter as well, at immigrationgirl.
And if you want to make an appointment with me, Emily, or any of our good colleagues, you can go to rnlawgroup.com and you can schedule an appointment. It's online. You don't even have to call. You can make an appointment. All of our schedules are available online. Thank you very much for tuning in. Thank you, guys. The next presentation will be the next Tuesday. Thank you.